You're watching the Law News Network, folks, and that was testimony from earlier today in the Frank BYBEE case out of Florida. He's a former sheriff's deputy accused of ultimately trying to steal an old lady's money and then plotting to kill her to try to cover up some of what was going on. Those are the accusations. He faces 18 charges. I think every single one of them is a felony. There was one lesser charge that was dropped before getting to trial. So that's where things stand in the BYBEE case. We're waiting to see if we can go back into live testimony. Considering that we might not be able to, we're going to talk about the Morris Brothers case because closing arguments in that case are coming up soon. Dan Schorr is here along with me again. Good to see you back.
Great to see you. Thanks for having me.
Former prosecutor. So look, this is a case where you have two defendants who are big money people. They're NBA players. They have multi-million-dollar contracts, and they have a lot to lose too. So not only could they be facing a couple years in prison if there's a conviction here, but they have a minimum of a 10-game suspension. Well, it's going to be more than that if they literally can't get out if they are convicted. So they've got big-name criminal defense attorneys. The case has been tried very, very well. And look, the state's case seems to be a mess because there are people getting up on the witness stand testifying that they were asked by associates of the victim to lie about the involvement of the NBA players and that everybody was going to get a kickback out of this, get some money out of them somehow. Does a jury get past that, or does the jury just look at this and say acquit?
That's a big part of what you'll see in closing arguments, because you're always trying to talk about the credibility of the witnesses, why you should credit this witness's testimony, why you should credit that one. And if someone has a motive to lie, and financial motives are very powerful, that's a big motive to lie. So the defense is going to make a big deal about that, as they should, because they're saying that because these basketball players have a lot of money, that the witnesses and the victim, alleged victim here, are motivated by money, that they're targeting these defendants so that they can make money from it. Now, of course, the verdict won't give them that money, but a civil suit will be very easy to win once there's a criminal conviction, because the civil suit has a much lower burden of proof. So that's a major motive here.
Yeah, I mean, and if there's an acquittal on the criminal charge, the civil case isn't impossible, but it gets harder because the civil case can't rely on the criminal case.
It's harder, but you could certainly win a civil case. We see that all the time. We saw with O.J. Simpson.
Yeah, right. The classic example.
Right, you have to show preponderance of the evidence in a civil case, which is more likely than not, beyond a reasonable doubt, in a criminal case, which is much tougher. And as far as the defense lawyers here, showing reasonable doubt, and you have a motive to lie, and people kind of admitting this motive was promoted to them, saying, hey, you can make money from lying. There might be reasonable doubt just from that.
Yeah, so look, this thing has been a hard case to watch because we have three defendants being tried at once. That means three defense attorneys. They're all angling at the witnesses a little bit differently, although in many cases the testimony was helpful to all three defendants. But it's been tough to watch from a viewership standpoint, but from a factual standpoint, this is a lot for the jury to try to unravel because you know, you've got accusations that police work were not thorough. You've got jurors really having to decide whether or not witnesses are credible. That's the job of the jury, but in this case, it's harder than the average case. But still, there are some little nuggets of testimony that are definitely worth reviewing. This is one of the best clips, I think, from the victim who was attacked. We know he was attacked. There are independent witnesses who saw the attack. He did go to the hospital. We know he wound up with a broken nose. It's just a question of who was involved in the attack. That's the question. The attack happened. That's settled. It's a question of who. But this is where they were really digging into him on cross-examination and asking him, hey, look, you know, you're trying to sue the NBA players. Why not sue everybody else that's involved? This is how he responded.
Earlier, we just heard Mr. Eckstein go through a number of text messages that you made regarding Marcus and Markieff Morris and whether you were going to file a lawsuit or not, associating $1 million, $5 million apiece, $7 million. Can you remember those text messages? We just saw them on the screen.
Absolutely.
Okay. And I noticed you didn't say anything about, boy, if I sue Julius Cain, that would be worth $5 million. You didn't have any kind of text messages like that, did you?
Yes.
You did?
Absolutely.
Where were they?
I wanted all of those guys just as much as I wanted the next. Absolutely.
That's not my question, Mr. Hood. My question is, when you wrote out names associated with dollars, associated with a claim that you would have regarding this, you never said Julius Cain. If I sue Julius Cain, that's going to be worth a lot of money.
Oh, he's a peon, so,
He's a
no,
peanut.
no, peon.
He's a peon.
Yeah, he's a peon.
He's a peon.
Yeah.
That's the difference. So when Mr. Eckstein asked you the difference between somebody having money and somebody not having money, Julius Kane is a peon and he doesn't have any money, does he?
It was never about that.
Julius Kane is a peon and he doesn't have any money, does he?
I don't know what he has.
Do you think he has more money or less money than Markieff and Marcus Morris?
That's a rhetorical question.
No, it's not.
Yes, it is.
Do you think he has more money or less money than Markieff and Marcus Morris?
Less.
So Julius Kane is a peon.
Yeah, being willing to take a charge for something where everybody was involved, absolutely.
Your word, he's a peon.
I could use more words than that, absolutely.
You knew that he was a friend with Markieff and Marcus Morris, correct?
Yes.
And you knew he was around with them all the time, correct?
I don't know. I don't know their movements.
Want to look in your interview where you say that?
When I say he was around them 4 years ago, prior to us not talking, yeah.
Yeah, about 4 or 5 years ago. You agree that he was... I'm sorry.
I said prior to me seeing them 4 or 5 years before I was attacked. Yes.
Right.
Leading up to today, I wouldn't know what he was doing.
And that's the 4 or 5 years ago. He was hanging around with them all the time.
Yes.
Right. And in your words, and correct me if I'm wrong, he was somebody that you had to tolerate because he was a friend of the Morris brothers.
Pretty much.
Yes.
Pretty
Yes,
much.
sir. Yes. Is that a yes?
Yeah.
But, and then about 4 years ago, you've already described whatever the text message misunderstanding was with Julius Kane. You remember that earlier where Julius saw a text message, you think he misinterpreted it?
I know, yes.
Okay. And as of that time, that's when your relationship with Julius, as with the others, it went south.
There was never a relationship with me and Julius.
But it was not a relationship where you said the shit hit the fan and you and Julius weren't cool anymore, didn't you?
I said that.
Yes, you did.
Can you show me, please?
Absolutely.
Thank you.
Look at, I'll come up because you seem to have a bit of a problem regarding this, but let's look at it. May I approach, Judge?
Yes.
It's the January 25th interview. Yeah, there it is right there. And it is page 4 and page 5. Actually, look at page 5. Page 5, yeah. Okay. Page... You see what on the right? Yep, that's it. So I want you to look at the very... is that 25th? Oh, you got the 26th. So look at page 5. And then I want you to look about 2/3 of the way down where it starts, says hood. Can't say that you were cool, the shit hit the fan, and that's when you were no longer cool with Julius Kane.
Meaning the text, yes.
Do you know what ARCH stands for?
Who?
ARCH,
No.
Arizona Recreational Center for the Handicapped.
Yes.
Have you ever been there, worked with any of their players? The handicapped athletes that are there?
No. Will I be willing to? Absolutely. I volunteer my time.
My question was, have you?
I have no reason to. I never heard about it until I went there. I'm not from here. I'm from Philadelphia.
You were there in 2015.
I was there to see a mentor of mine who traveled here from Reno, Nevada.
Had you never been to ARCH before that?
No.
Was that the first tournament that you were at? The one that on January 24th?
The first tournament that I was at there or in Arizona at all?
At ARCH.
That was my first time there, yes.
Do you know Jacob Miller?
No.
Do you know what he looks like?
Can't say I do.
Are you seriously telling us today that you did not know the Morris brothers' car?
I mean, I heard about it. I mean, I never seen it physically.
Do you remember telling Detective Santos on January 26th that their car was a Rolls Royce?
No.
Take a look at page 21 of the January 26th interview. Tell me when you get there.
I'm there.
You there?
Yep.
Let me get there. Oh, I'm sorry, page 21. I'm thinking January 26th. I do that.
All right.
Court reporters hate that. I'm sorry, Mr. Hood. We've been the victims of bad information here today. January 25th at page 21. You see the top 8 lines or so of page 21?
Yes.
Does that refresh your recollection that you knew what kind of car that the twins drove?
Yes.
What was it?
Like a Rolls Royce. That's what I said.
So when you told us earlier that you didn't know what kind of car Markieff was by, is that a mistake or is that? What is
Yeah,
that?
you can say that. Yes.
Mistake. So now but now you know.
Yes.
Okay. So when you saw him buy his car, where was his car parked?
Where I marked previously.
Was it in the parking lot?
I don't remember.
Because Detective Santos asked you if it was on Coulter Street, and you said no, it was back. And you said you first saw him when you veered out towards your car in the parking lot. So does that refresh your recollection where Markieff Morris was? Next to his car?
No.
No.
The more time went by, the more I remember.
I'm sorry, say that again?
The more time that went by, the more things started to come back to me. Right here, it was relatively, it was everything.
So that was testimony from Eric Hood, the victim in the Morris brothers trial. The question is, did they do it? Now, Dan, you're a former prosecutor. That cross-examination really ripped into this guy, and the victim gives this nugget that the defense properly just repeated back to him time and time again. Oh, you don't go after the guy who doesn't have any money because you say he's a peon. Now, it means someone who's held in, bondage, slavery-like labor conditions. That's what it means. For those of you thinking there's a snarky secondary meaning of it, we're not talking about that, but the bottom line is that several of the people who were alleged to be involved in this attack didn't have any money. Well, it has to do with these allegations that there's witness tampering, that the victim, Eric Hood, and some of his associates, his friends, are expecting some big payout in a subsequent civil suit from these folks. Good idea to paint him in this negative light that he's just out for money. Is it a winning tactic?
It's definitely the right move on the defense side because, as I said before, any motive to lie and financial motivation is a big motivation, shows that he might not be telling the truth, and that could establish reasonable doubt. On the flip side, though, if you're the prosecutor, you're going to argue it's human nature that if multiple people attack you, and you're going to think, wow, a couple of them have money and I can sue them. Now, he was kind of reckless in the text messages that went out and talking openly about this. The smarter move would just be quiet about the financial motivations as the criminal case proceeds. They didn't handle that smartly, but it doesn't mean that he's not telling the truth. If you or I walked down the street here in New York and we got punched by someone who's rich and famous, we would probably think, wow, I'm going to earn some money from being punched by that person. We might not, it wouldn't be smart to start texting that as the criminal case is proceeding.
Yeah,
but
right.
it's not, it doesn't necessarily mean he's lying. It certainly provides a motive to lie, and that might be enough for reasonable doubt, but that in itself doesn't mean that he's not telling the truth.
Not in and of itself. So there's a couple other pieces of information here that I'll pile upon this debate in just a second. But let's talk about cross-examination, because in this case, I've been impressed by the lawyering all the way around. The prosecution's been excellent. The defense attorneys have been excellent. The judge is very, very sharp. She's given me that impression just as an observer. We've had a couple of local attorneys on who have also said, hey, we have practiced before her, and yes, she is very much on the ball. But I thought the way the defense handled that line coming out of the defendant was superb. I mean, on cross-examination, what is it that an attorney is looking for to try to get out of a witness? One thing is a memorable line.
Right, and you want to repeat it multiple times because the jury needs to really understand it, and maybe they missed it the first time or the second time. So when you keep saying the word again, it's going to stick with the jury, and then you recall that during cross-examination again and again, and then ultimately again during your summation where you can say, remember when you heard the witness say this, it's going to stick in their mind. The jury is hearing a lot of information. As you said, it's sometimes hard to watch as a viewer because there are so many defense attorneys cross-examining people. That makes it hard for the jury to focus also. So you want to make sure that the thing you want them to note, they're going to note. So you really need to emphasize it when there's so much talk that might not be as meaningful to them.
Now, cross-examination is all about collecting these little golden nuggets of information. Direct examination is trying to get the narrative out of somebody, and I think the state did a good job of that with the witnesses, including the victim. He got the victim to tell the story, had the friend tell the story and say, hey, look, we were walking out of this rec center. I'm near the door. There are a couple of stragglers hanging around. One of them punches me in the back of the head, and then this group of a number of people gang up on me. And, you know, I try to get away from them. They ultimately catch up to me again. And then that's where the attack happened, in a very dark area. Now, there's a lot of he said, she said about who was involved, when they were involved, whether or not the individuals were involved for the whole thing, just part of it, what roles everyone played. Markieff Morris is hedging that only one person directly put him in the scene of the attack, but the state, from what I understand, is going with the theory that he was sort of acting as a lookout to prevent others from coming to aid or sort of stalling people or whatnot while they roughed this guy up. So there are a lot of theories flying around here. Is it possible, or is it wise, should I say, for the state to sort of latch on to both of those theories, that Markieff Morris specifically was both involved in the actual, you know, I'm picturing a cartoon scene where a fight happens and all you see is a cloud of dust and you can't tell who's throwing what punch and when. Is it okay for the state to say, well, that you could find that, members of the jury, but you could also find that he was a lookout trying to hold people back so that the fight can continue?
That's a really interesting question. Both theories satisfy the legal requirement, because if you're acting in concert for any part of the assault, including being a lookout, then you're on the hook criminally for the whole assault and everything that's been done. And you don't necessarily have to show a definitive theory to the jury legally, but the thing is, when you have credibility as a prosecutor, and when you as a prosecutor say, we're not sure how this actually happened, you need to have a really good explanation for that for the jury, because the jury may think, well, why should I believe the prosecutor in their case if they don't really know what's happened? Now, sometimes prosecutors just don't know. We've had murder prosecutions where the body's never found and they don't know how the cause of death actually happened, but yet they could get a murder conviction. So it can be done, but really having a theory where you could look the jury in the eye and say, this is exactly how it happened, the evidence shows that beyond a reasonable doubt, and that's why you should convict, that's much more powerful than saying, it might have happened this way, it might have happened that way, and either way you can convict. So that's usually how they think about these
Exactly.
things.
My guess is what the prosecutor is going to do in about 10 minutes when they start back up again is turn around and say, okay, look, different witnesses saw different things at different times. You could believe all of them and it results in the same conclusion. That would probably be the best way to win it if I were the prosecutor.
And the defense is going to say, listen, they all contradict each other. You can't believe anyone. And there is reasonable doubt. No matter who you look at, there's someone else who contradicts that witness, so there has to be reasonable doubt. That's going to be the defense argument.
And not just are there fact contradictions, but there are biased motive issues here too. When you pile them on top of one another, the case just gets more and more and more damaging.
Right, people have a motive to lie, and as I said before, anyone who's assaulted by a rich celebrity, or most people, are going to start thinking about how they can earn money from that in a civil suit. That's the nature of our society. We're a litigious society, so it's not unusual that they would be thinking about that, but it does color the way they handled it, the way they expressed that, and it colors their credibility because it gives them a motive to lie and fabricate.
Exactly. I want to turn now to some of the testimony from one of the witnesses who was part of this youth basketball game. He was involved in the audiovisual crew of in some fashion, who ultimately saw some of what was going on, and he testified on the stand that an associate of the victims asked him to lie about it. Here's that critical testimony.
When you get down there, do you see anyone?
Yes.
All right, who do you see?
The lady who initially told us.
All right. Do you see any vehicles down in that area?
There was a vehicle, which I think was her vehicle, parked on the street, and she was helping him up off the ground. and helping him, and she was bringing him to her car.
Okay. Do you remember if anyone else was with them, those two individuals?
No, I don't remember.
Okay. And is it you, Jacob Miller, and Joe Murray down in that area?
Correct.
At any point, did you call the police?
No.
Do you know if the police were called?
I don't, at the time, no, but I believe that.
Objection, Your Honor.
Sustained.
And when you see the individual that was getting beat up and the female, what do they do while you're down there?
The individual beat, what does he do?
Yes.
I don't even know if he was even speaking or anything. I think he was just, he had just gotten beaten up, so she helped him get to the car.
How does he appear to you?
Beat up.
And when you say beat up, what does that mean?
I couldn't see his face close up. I mean, by the time we had gotten out there, she was already helping him up into his car, so I didn't really get to see what he looked like.
All right. Did you help him into the car?
No.
Do you know if Jacob Miller helped him in?
I don't think Jacob did.
Okay. And do you know if Joe Murray helped him into the car?
I don't remember.
Okay. At that point, what happens?
At that point, they get into their car. I believe she had taken him to the hospital, and me, Joe, and Jacob walked back to the parking lot, and I got my kids back on the van, and we left the arch.
All right. And you've been interviewed a couple times after this by the police department. Is that correct?
Yes.
All right. And you were also contacted by an individual named Alonzo Hickerson. Is that correct?
Correct.
When were you contacted by Alonzo Hickerson?
I don't know the exact day, shortly after the incident occurred.
Okay. And what was the nature of that? Was it by phone?
Yes.
What was the nature of that conversation?
The initial conversation, the initial reason he was calling me had to do with basketball. I don't remember what exactly about basketball. We're both coaches, we coach at a prep school, so we talk about basketball topics all the time.
Was there any discussion about this incident?
Yes.
What was that discussion about?
It initially started with him asking me if I had heard what happened.
Okay.
I responded telling him I had heard what happened. At some point in the conversation, he had said something along the lines of, I don't know the exact words or verbiage that was used, but he had made a comment about what I saw, and he asked me if I had seen the Morris brothers beat up the gentleman that got beat up.
Okay.
I initially, go ahead.
Go ahead.
Initially responded saying no. And then he continued and said something along the lines of, well, if you give a statement saying that you seen or saw the Morris brothers get beat up, the gentleman get beat up by the Morris brothers, the gentleman getting beat up is going to receive a settlement, and you will receive some kind of compensation / money, something like that.
Okay, so what did that mean to you? What did you believe that he was trying to encourage you to do?
Give a false statement.
All right, and had you already talked to police by the time he made that call?
I don't recall. I believe it was before I talked to detectives, but I don't remember if it was before or after.
Okay, and in response to that, did you indicate to him anything about that?
Never. I initially shot down the idea. I told the gentleman, Alonzo, I have no interest in giving a false statement. I tried to laugh it off, honestly, because I was shocked that somebody would ask me to do something like that. So I tried to kind of play it off. You know, when you're in a conversation and someone brings up some kind of crazy idea, I try to quickly change the subject and veer away from the situation and told him I wasn't interested.
Okay. So did that influence any of your statements to police?
Nope.
Did that influence any of your statements here in court today?
So that was one of the more critical pieces of testimony in the Morris brothers case out of Phoenix, Arizona. Again, if you're just joining us, it's a case involving a couple of NBA players, Marcus and Markieff Morris, and a third co-conspirator named Gerald Bowman. They are on trial together for assaulting a man, allegedly, named Eric Hood. There were 2 other people accused as part of the attack. Those 2 others took plea deals and admitted guilt. So an interesting scenario here. Now, that's some of the more critical testimony, because this is the testimony where one of the independent witnesses said he was approached by this Alonzo Hickerson, who is an associate of the victim, and it was suggested that he lie about it. That's witness tampering.
Absolutely. If that's true, it's not only a crime in and of itself, but it undermines the whole prosecution case when you have someone who knows the victim trying to get people to lie. So whether the jury believes that or not is hugely important here. It's hard to see how you get a conviction if someone connected to the victim is believed to have told someone to lie.
Yeah, a lot of what ifs here. The lead detective didn't even know about some of this witness tampering until 2 weeks ago. Well, this case goes back a couple of years, so that's an issue. Another interesting thing, the Morris brothers, when they were first approached, they've had their photo taken with the victim umpteen times. They've known him since they were growing up as kids, but they claimed they didn't know him when first approached by police. I'm sure that we're going to hear about that when closing arguments start any moment now. But we also want to listen to another brief clip as we wait for closing arguments. This is the lead detective. How many times did he ask the victim, Eric Hood, exactly who attacked him, and how long did it take that victim to change his story? You'll find out.